My lord, I can hear you loud and clear.
Okay. I'm talking about Mr. Samuel. Can you hear me too? Because I
not hearing.
Okay, can you hear me too? I said,
I can hear you, my lord. I can hear you, my lord.
All right. So you are done because my registrar is back. So please call up the matter that was stood down. So we start off again.
Case number NICN.
I can barely hear the code, my lord.
Okay.
Case number NICN/LA/331/2021 between Heavy Machinery Dealership Limited and 1 Mr. Sani Yakub, 2 Matrix Global Trading and Sourcing Limited.
Can you hear them? Sorry, my lord. We can barely hear, my lord.
Are you muted?
My learned friend here can barely hear, sir.
Okay, let's see. If you're muted, you unmute you. Check. Nobody's muted. So he said even the other council cannot hear us properly. However,
my lord, I have no issues hearing you properly. It's very clear on the part. Yeah. I just wanted to state.
Okay.
Can you hear?
Now my registrar is back. And Mr. Samuel, tell us what is the outcome? Hello? It's not hearing us properly. Okay. We can't spend all day here in court. I guess what we'll do now is this. Mr. Samuel Ibrahim.
My lord, we can barely.
You can barely hear me.
Yes, my lord. Okay, it's better now. I'm using my client's device now. It's a bit clearer.
Okay. My registrar has come back. Then yes, I wanted to find out from you what transpired.
Yes, my lord. I will check the records of proceedings in my custody.
Yes.
I may be wrong, but I have concluded that those documents were tendered during cross-examinations on 23rd of May, 2024. For the records I have here. Because the line of question is there during cross-examination portrays that those documents were tendered through the defendant. That's the first defendant.
Okay, it was tendered through somebody.
Yes, through the defendant under cross-examination.
Okay.
However, my lord, my memory can be short, but I think I recall very well that day that my lord did not mark those documents and I think there were objections. So my lord didn't rule on that objection. And my lord said, we'll come to it at the next adjourned date. At the next adjourned date, which I admit is my fault, I didn't remind the court. I should have reminded the court that at the last adjourned date, this is what transferred. These documents were unmarked and my lord has not ruled on it. I think I remember now that that's what happens. Maybe my lord can check maybe your records, maybe you can see something. For those two documents, it was tendered through under cross-examination.
My lord, sir, may I respond?
Yes.
My lord, I had my associates also join in the search, in terms of the court records. And we checked that instead of me. And there's nothing, no record whatsoever on the court record, even on the part of the registrars, indicating that those documents were tendered and were tendered through the defendant, even under cross-examination. be that as it may, I'm even happy he has said and he has admitted that he forgot to even tender it even on the following date.
I didn't say that I forgot to tender it.
My Lord, I'm still on my feet. My Lord, I'm still talking. My Lord, whatever documents that we objected to, my Lord, reserve them for final written address, as is my Lord's usual practice and is the court's usual practice. So there is no way my Lord could have adjourned an objection for the following day because my Lord wanted to rule on it, on the next date. All objections were reserved for final written addresses. Yes. My Lord, no record. My Lord, we have checked the court's record. We've spent over 30 minutes checking the court's record. On that same 23rd day of May, nothing, my Lord. He has also further admitted that he forgot to tender it. So,
I didn't say so.
I'm not sure what we are talking about.
My Lord, this
we have filed
is misleading, my Lord.
Final written address.
I didn't say so. I never said so.
Calm down.
I never said so.
Use what? Out of decorum for this.
We are recorded. I never said so. I never said I forgot to tender them. I never said so.
2024, not even 2025. Okay.
I never said so.
My Lord.
Those documents were tendered under preservation, my Lord. I stand by my word.
There is nothing we can do now except to allow you to go and write and file your final written address.
My Lord, these documents are in the court custody. I wanted to suggest that I recall the witness to come back so that I can tender those documents properly under.
The court doesn't have this type of time, because if the court had it, it would have finished this case a long time ago. I cannot tell you to recall a witness now, re-examine him and tender something through him so that it can be marked. Because because I have nothing to hide. I gave you the court's records, which you have gone through, which you said the court received the documents and did not mark it and adjourned it to another date to mark. Who does that?
Counsel's advocacy cannot be likened to the evidence of the court record. Counsel's advocacy, counsel's remarks cannot be seen as the court record or the evidence of the court record is clear and diligent, my Lord. My Lord, they have not filed a written address. There's nothing before the court at this particular point in time. After the court has adjourned twice for adoption, for them to take any steps regarding anything whatsoever. My Lord, I am pushing that this matter be resolved today. My Lord, they have chosen deliberately not to file a written address.
My Lord,
not out of any sort of error or whatsoever, my Lord. My Lord, we are ready to proceed. And my Lord, I am insisting, my Lord, out of respect for the court, that I want to adopt my address because I'm ready to proceed. My Lord, there is no reason why we should even seek a further adjournment to enable them file a written address. There is no reason, my Lord. They have not
presented of justice,
documentary evidence whatsoever to show that they are entitled to an adjournment. My Lord, if this adjournment is even granted, there's no basis for it. There's nothing before the court. They have said we've checked the court's record. There's nothing to show any sort of discrepancy on the court's record. My Lord, counsel statements and indictments on the registrars too, and even on the court's records. It's an indictment.
Mr. Kanyao, please wait. I want to ask him a question. Now, yes, Mr. Samuel, I hope, are you referring to the documents marked exhibits D1 to D12 respectively?
D1
on the 24th.
This one's for April.
This one's for
April. I read out those documents for me so I can know whether it is the same thing or not.
Sometimes in May.
You said sometimes in May.
Yes, my
okay,
Lord.
I went
my Lord can assist by reading out the documents, my Lord.
This is May, yes. Cross-examination.
Yes.
And on the 23rd of May, what happened in this court was cross-examination.
Yes, my lord.
And somebody said his name is Sunny.
Jacob, that was the defendant's witness.
Jacob, and he said he stays. He lives in Amsterdam in the Netherlands. Was it?
Yes, my lord. He was present virtually, my lord.
He said, okay, virtually. He left.
Yes.
He left these shores about 1 year and 10 months when the case had started. That he did not leave because the police was looking for him. That is not aware that the Interpol and Nigeria police wrote letters for him. He said he now works in Netherlands and he has asylum. He said he works with HMB almost for 5 years.
There's something that's omitted, my lord.
Yes, what?
Before now, I work in Netherlands.
Okay, show me the letters that the petitioners
as accomplices
got. Yes.
As accomplices.
Yes.
It was at that point those letters were tendered.
My lord, where is the evidence that at that point those documents? My lord, where is the evidence? This is examining my witness. This document that he's making mention of is
my lord, look at your records, my lord.
This is examining my witness. So where is the evidence? What does exactly mean?
D12 now, listen. The court has decided that the claimant should go back, write his final written address so that this matter can be concluded. That is just what I have, because I can't see where something was admitted in evidence, and the court admits something in evidence and then adjourn for me to mark. Who does it? I don't do that because I'm a human being. I may forget. So when I take it in evidence, usually I ask the other side. I said, I'm going without any. I think I even wrote it there. Without all the things that I admitted that day, I said without any prejudice. So the right, inalienable right of the other counsel to oppose to
during
that
address.
These documents are admitted in evidence and marked exhibits
exactly,
1
my lord.
to yes, and that is what is here.
Yes,
so I can't imagine having taken in something and not marking it, especially adjourning it to another date. No, I don't do that, honestly.
May I respectfully add that I do not see any reason why this honorable court is adjourning another time again, additionally, after the court's stern warning on the last adjourned date.
Even cost awarded.
Even cost awarded, exactly, my lord.
Yes.
That they should further written address. My lord, and may I add that this is the claimant's case, this is not the defendant's case. May I add that it's been over a year since we filed this final written address. My lord, they have not even, my lord, even after a month ago, that my lord had asked, okay, whatever it is you want to do it before the next adjourned day. My lord, they only came in yesterday. My lord, this shows the disrespect for this honorable court in terms of this court's authority. That they would come on the day before the adjourned date and say they want to even start doing whatever search they wanted to do. My lord, there's nothing before this court to justify any adjournment. My lord, I am stating that firmly. There's nothing. They have not presented anything before this court. My lord, this application is ripe and very ripe. My lord has indulged them, has given them any extra. My lord, this issue has been. My lord, in December, my lord gave them a stern warning. The last adjourned day, my lord gave them a stern warning. My lord is my lord saying that she will continuously indulge them forever and ever until they are ready to file a written address. My lord, justice is a two-way street. Our clients are suffering by being in this court. This man has, the claimant has made grave assertions against them in terms of their positions and whatnot. My lord, we have nothing to hide, but there's no justification.
Okay,
my lord, I'm respectfully saying that there's no justification, my lord.
My registrar,
we have every right to adopt our written address at this particular stage. And I so submit, my lord. There's no basis, my lord, under which,
case,
my lord, there's no basis for this adjournment to enable them for that written. My lord, there's no basis. I respectfully submit.
No, Mr. Kanyao, don't go there, please. This matter, I usually take my virtual hearings by 12. This one, for reasons best known to whatever, I was billed for 1:30. And look at the time, it's 3 o'clock. And I'm talking about an exhibit that I did not, I'm not sure about. Let's him write the document and maybe mention this issue of exhibits received but not marked. Mention it in that your address. And the court will look at it. And when the court looks at it, at least I still want to believe that I have some conscience. I will look at it. If you're right, then I will know what to do for you.
Thank you, my lord. I'm very grateful.
Yes.
My lord has checked her records and could not trace any of those things. My lord, in any event, my lord, I will not further prolong this matter. If my lord is going to indulge them at our own expense and at the court's, at the honorable court's expense, my lord, I will be asking for pecuniary costs, my lord. My lord, this is untenable.
No, Mr. Kanya, if you want to ask for costs, that's quite all right. You have the right. But you have been trying to play down the decision of the court to.
My lord, I'm not playing down the decision of the court. My lord, I'm respectfully submitting, my lord. My lord, I'm saying that there's nothing before the court to justify an adjournment. That is my position.
We have all seen that there is nothing because I submitted my my records and all of you looked at it. So if you want to ask for because that is different from what I'm saying. What I'm saying is that I cannot write a judgment based on the defendant's final written address and not the claimants. You're the claimants.
I'm the defendant, my
defendant's written address and not the claimants. Who does that? Nobody.
My lord, yes, my lord. But is it even after they've been given ample time to put up their written address and they refuse to?
So, given ample times, yes, but for the court to go on a one-way drive both ways on a one-way lane, it's not good.
Okay, my lord. So what then happens?
I have to listen to him and hear him, and then write the judgment based on what both of you have submitted in your address.
My lord, that is fair. And I know this court is a court of fairness, justice, and equity. And this court has never acted otherwise. My lord, may I just add this now? What if by the next adjourned date, this same position, this same status quo is being maintained? What will be the court's options at that particular point in time?
You can't let me foretell what will be my options because
no problem, my lord.
It will not happen.
Okay,
it will not happen.
My lord, I'm just saying in the event that so happens, my lord, if my lord can give a clear directive, an order of the court and being recorded that they have to do the needful by next adjourned. Otherwise,
if what you're saying happens, the court will make any order or orders it deems expedient to make on that date. Yes.
My lord, what I'm just saying, my lord, is that in the event that they don't file, if my lord can make an order that they should file, or otherwise we may proceed in their absence of filing. That is all I'm saying, my lord, because my lord
is there, May 12th.
May 12th. How do you stand on the 12th day of May? Please, both of you. Mr. Samuel and Mr.
My lord, I'll be asking for a heavy cost, my lord. I'll be asking for heavy cost.
Can you even answer my question? I said, how do you stand on that date?
My lord, 12th of May is not convenient. May we ask for 13th of May?
How do you stand on 13th? How about you, Mr. Samuel Ibrahim? 13th of May, is that all right for you, sir?
Sorry, my Lord, let me check.
13th, okay.
My Lord, and before your learned brother Joseph Mwaneka on that day, we can go to 18th, no, 19th.
Remember, you're the claimant too.
Yes, my Lord. 19th of
Okay.
May.
My Lord, I can't take 19. I can do 20 May.
19, 20, 21st, and 3.
My Lord, 20 May is convenient.
Those days are not convenient for the court.
I understand they are not convenient. It's not convenient for the courts. Give him any. If you do, you want a longer date?
My Lord, I don't want any longer date. My Lord, if you can give me an earlier date, my Lord, please, my Lord. We have been here on this.
Mr. Kanyao, are you? What is this you are exhibiting now?
My apologies, my Lord.
Upon apology being considered. The 20th, somebody said it's not convenient for you.
No, it's convenient for me, my Lord.
20th.
May 20 is convenient.
Okay. Mr. Kanyao.
May 20 is convenient, my Lord.
Okay. Okay. Mr. Samuel.
Yes, my Lord.
I hope you know what you will do. You calculate the default fees, you pay, and file,
May 20
and serve, so that he can now reply.
As God pleases.
Yes, please do that. 20th May, you said?
Yes, my Lord. 20th.
26th for adoption.
May 20, yes, my Lord.
Okay. Okay, this matter is now adjourned to the 20th day of May 2026 for the adoption of the final written addresses of both learned counsel to the parties.
As God pleases. We're very grateful.
My Lord, sir,
okay.
What of my submission on cost, my Lord?
I order the defense, the claimant's counsel to pay up the cost for the last initially awarded by this court on the last adjourned date.
I will do that today, my Lord.
Pay it up.
Now, I made, my Lord, sir, I made a submission on cost today, my Lord. I don't know if my Lord would consider it and grant or review.
Iwana, oh, sorry, not Iwana. Mistake, Anya. Let me, I shall make note as to cost today.
As God pleases.
Okay. Okay, today is 29/4/26. The court shall rise.
Well done, my Lord.
Thank you. Thank you.
Thank you, my Lord, for your time. I'm most grateful, sir.
Very well, but you have to desist from the way you behave today. It is quite unusual and it's not acceptable to the court. While I'm talking, you are talking, and you are trying to. Anyway, don't do this again.
My Lord, my apologies, sir. I'm really, really honestly sorry. I didn't even know that you were talking at some point. I apologize, my Lord.
Apology being considered. Apology being considered now. Yes. Okay.